Okay, this will be a jury charge at 2:25. Here we go. Now, for the ladies and gentlemen whose names were not called, that will conclude your service. Please don't wonder about how these selections are made. It is not by any logical process. I want to thank you folks for your patience and attendance here for jury service today. And I do need to ask you to just check in with the jury commissioner on the second floor. So happy New Year to you, ladies and gentlemen. Thanks for coming, and see ya. And for the members of our trial jury, we're going to take care of a few preliminary matters this afternoon and then adjourn for the evening in about 10 minutes, I suppose that will be. We're going to swear you in as trial jurors in the case. Then I would read the indictment and state the pleas of the defendants to the indictment, and then I will give you just a few preliminary instructions. So at this time, I'd like you to please stand and take the oath as trial jurors. Thank you. The indictment in the case is the State of Arizona versus Carlos Gallegos and Jose Jimenez, and charges count 1, burglary in the first degree. On or about the 30th day of July 1992, Carlos Gallegos and Jose Jimenez committed burglary in the first degree of a residential structure located at 634 West Cali Street, Tucson, Arizona, belonging to or occupied by Carmen Gregg, while knowingly possessing a deadly weapon, to wit, a Colt .38 caliber and a Smith & Wesson .41 Magnum, in violation of Arizona revised statutes. Count 2, aggravated assault. On or about the 30th day of July 1992, Carlos Rivera Gallegos and Jose Jimenez assaulted Carmen Godoy with a deadly weapon, to wit, a Colt .38 caliber and Smith & Wesson .41 Magnum, in violation of Arizona revised statutes. Count 3, aggravated assault. On or about the 30th day of July 1992, Carlos Rivera Gallegos and Jose Jimenez assaulted Ronnie Godoy with a deadly weapon, to wit, a Colt .38 caliber and a Smith & Wesson .41 Magnum, in violation of Arizona revised statutes. Count 4, aggravated robbery. On or about the 30th day of July 1992, Carlos Rivera Gallegos and Jose Jimenez robbed Carmen Godoy and Ronnie Godoy while aided by one or more accomplices actually present, in violation of Arizona revised statutes. Count 5, armed robbery. On or about the 30th day of July 1992, Carlos Rivera Gallegos and Jose Jimenez robbed Carmen Godoy and Ronnie Godoy while armed with a deadly weapon, to wit, a Colt .38 and a Smith & Wesson .41 Magnum, in violation of Arizona revised statutes. Count 6, kidnapping. On or about the 30th day of July 1992, Carlos Rivera Gallegos and Jose Jesus Jimenez kidnapped Carmen Godoy with the intent to aid in the commission of a felony, in violation of Arizona revised statutes. Count 7, on or about the 30th day of July 1992, Carlos Rivera Gallegos and Jose Jimenez kidnapped Ronnie Godoy with the intent to aid in the commission of a felony, in violation of Arizona revised statutes. Count 8, kidnapping. On or about the 30th day of July 1992, Carlos Rivera Gallegos and Jose Jimenez kidnapped Melinda Moreno with the intent to aid in the commission of a felony, in violation of Arizona revised statutes. Count 9, on or about the 30th day of July 1992, Carlos Rivera Gallegos and Jose Jimenez kidnapped Rudy Romo with the intent to aid in the commission of a felony, in violation of Arizona revised statutes. To these counts, the defendants have entered pleas of not guilty. Now, ladies and gentlemen, I'm going to tell you some of the rules of law that you will have a duty to follow in considering this case. It is your duty to determine the facts. You must determine the facts only from the evidence presented in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice, and you should not concern yourselves with any opinion that you feel I have about the facts. You are the sole judges of the facts. You must find the facts from the evidence produced in court. This consists of testimony of witnesses and exhibits. At times during the trial, one of the attorneys may object to a question that's being asked or to an exhibit that's being offered into evidence. And an objection is a request for a legal ruling on the admissibility of the answer to a question or the exhibit. And you should not concern yourselves with which attorney may make an objection or with what the legal basis for the objection is. Just as you decide the facts, I have to decide the law. Now, if an objection is overruled, it means a witness may answer a question. If it's sustained, the witness may not answer the question, and you should not guess about what the answer to that question might have been. Just regard the question, and we'll move on to another question. You must decide the accuracy of each witness's testimony. To do this, you should keep in mind the witness's ability and opportunity to observe. Their memory and manner while testifying, any motive or prejudice the witness might have, and any inconsistent statements. Consider each witness's testimony in the light of all the evidence presented in the case. During the trial, the attorneys are permitted to stipulate that certain facts exist. A stipulation is a fancy word for an agreement, and it means that a jury may consider a fact that is stipulated to in their deliberations in the case. I don't know if you will have any stipulation or not. That's what they mean if we have one or more. Now, let me give you what we call an admonition in the case. This is a short list of things to do and not do to help ensure a fair trial for both sides. First of all, you should not discuss our case or anything connected with it among yourselves or with anyone else while the trial is in progress. To avoid even the appearance of improper conduct, I'm asking that the jurors and the parties to the case not have any conversation of any kind while the trial is in progress. If you happen to be seen talking to each other, we won't know what that was about, and we'd have to inquire, and that's a big headache. So if you see the attorneys in the hallway and elevator and they don't greet you and ask you how you are doing, they are observing this admonition. To help us with this, we have given you juror badges, which you will find attached to the envelopes. And I ask that you wear these at all times when you're downtown. In fact, I'll ask that you put them on before you leave the courtroom this afternoon. Thank you very much, ladies and gentlemen, for your patience during the presentation of the evidence and the argument of counsel. The court charges you that the mere fact that there has been an accident and as a result thereof the plaintiffs have been injured does not in and of itself entitle the plaintiffs to recovery. In order to recover in this case, the burden is upon the plaintiffs to prove by a preponderance of the evidence that the defendant was negligent and that such negligence was the sole proximate cause of the accident. Negligence is the failure to exercise reasonable care or the violation of some positive duty imposed by the law. Reasonable care is that care which a reasonably prudent person would have exercised under the same or similar circumstances. A proximate cause of an event is a cause which, in the natural and continuous sequence, unbroken by any intervening cause, produces the event and without which the event would not have occurred.